Well, with more on the case that goes before the U.S. Supreme Court on Wednesday, we are now joined by Dan Rayfield. Mr. Rayfield is the Attorney General for the state of Oregon. Mr. Rayfield, thank you for taking the time.
Absolutely. Thanks for having me.
So, your state is taking on these Trump tariffs. In fact, your Solicitor General will be making arguments not only on behalf of Oregon, but 11 other states that include Minnesota and New York. Walk us through the argument that Oregon will make before America's top court.
Yeah, and it's pretty simple because you can overcomplicate legal things pretty fast. This is a case where you have the Constitution that gives the power to Congress to set tariffs. The Congress has given a little bit of power to the president, but they've done so by creating safeguards for the economy, safeguards for small businesses and consumers, sideboards, if you will, that limit how high they can be, the duration, require factual findings. Now, normally presidents use these statutes. This is the first time any president has not used these statutes and has now attempted to take this creative way using an emergency power to implement tariffs in a way that no other president had. So that's kind of the crux of this, where we're saying, hey, Mr. President, if you want to do tariffs, you got to do it the right way. You don't get to skirt these laws that Congress passed to implement your tariffs. And so that's what we'll be arguing on Wednesday.
Okay, but to hear it from Donald Trump himself, these tariffs, he argues, have been necessary because he has actually used them to negotiate better deals out of countries, including from this one, forcing essentially other jurisdictions to make concessions. How do you counter that argument?
I mean, that's what I would say if I was doing unconstitutional things as well. But the fact remains, and history tells us that numerous presidents have been able to successfully effectuate good trade policy that's good for Americans, trade policy that's good for Canadians, trade policy that's good for the world, without having to abuse an emergency power. And in fact, President Donald Trump used the appropriate statutes during his first 4 years. The thing is, he didn't like those. He didn't like that Congress put constraints on him. And that's why he wanted to be creative and do this thing that no other president have had. Now, we also know that this president will say and do anything he wants when it comes to social media. So you really got to look at those underlying facts.
But the law that Donald Trump is using here, that emergency powers law, it does stipulate that the executive can use certain tools to deal with threats of, quote, national security, foreign policy, and the economy of the United States. So how difficult of a case will this be for plaintiffs like yourself to win?
Well, you got to remember, a panel of 3 judges in New York already ruled this was unconstitutional. A en banc panel in the federal circuit ruled that this was unconstitutional. So you have multiple levels of court saying, hey, President, you can't do this. Factually, the most important thing for people to remember is that no other president in the history of our country has ever tried to use an emergency statute to implement tariffs. They have used the statutes that Congress intended to use tariffs. And that's really what's going on here. You can try and shoehorn something in to this emergency statute, but that's just not what it was intended for. There are specific statutes that talk about tariffs that are what the president should be using.
You mentioned past court rulings, but with this U.S. Supreme Court, you have here 3 justices who were appointed by Donald Trump, and they have, since the spring, generally favored expanding the executive powers of the U.S. president. Are you worried about that?
Not at all. I believe that the language of the statute is incredibly clear. And I believe we have been successful with judges that were appointed by Trump in the past. We've been successful with judges that were appointed by Republicans. I also think when we start talking about where justices have been appointed, we really lose the context that when you put that robe on in our courts, you are supposed to be an independent jurist and do your best to divorce yourself from your philosophical leanings as you approach these cases. I really do believe that as these judges approach this, they're going to look at it from the health of our democracy and what was intended to be 3 unique branches of government, co-equal branches of government, as they apply this law. And so I do remain hopeful and optimistic as we move forward, because I think the facts of this case were just as strong on day one as they are right now.
Okay, forgive me. I do want to push on that, though, because again, you do have a high court that has favored expanding the powers of the U.S. executive. How is that not going to factor in? Or perhaps you can explain why you think that will not factor in this case.
Yeah, and a lot of the headlines where you're seeing those rulings that are coming into the Supreme Court right now, and I think the ones you're probably referencing are on procedural issues about how are we going to deal with universal injunctions across the nation. This is the first case that'll be going in front of the United States Supreme Court on the merits of what is going on here in our country. In fact, some of the doctrines that we are using to limit and curb the power of the executive branch are conservative doctrines that were developed by the conservative part of the court. So you think about the non-delegation doctrine, that's really nerdy and weedy. And we think about the major questions doctrines. But for folks to know, these are arguments that we're making that were developed through conservative jurists. So it is really going to stress test these judges as they start reviewing this case. But what we all know as Americans is that prices are going up. And what we know as Americans is that we never intended to have a policy that the president could implement willy-nilly because he didn't like the tie that some president of Brazil was wearing, or he didn't like the way that the Canadian government spoke to him on social media or did these various things. That's not good trade policy. No president should have that type of unilateral power. And if the Supreme Court rules against us, that's the type of power this president will have. And I do believe that that clarity in America is incredibly important because that will give Congress power to then change that law to cabin in the president's authority.
Mr. Rayfield, thank you for this. Appreciate the time this evening.
Yeah, thank you. Good to see you.
And you.